Sherry, this is Andre. I need y'all's help. Something bad is happening to me, and it keeps happening, and I don't know what's going on. I need some help. I think I'm in hell. I need help. Somebody needs to come and help me. I need help, bad. I'm desperate. I'm afraid to go to sleep. So when you get this message, come by the house, please. Hello?
On April 5th, 2023, Andre Lee Thomas is scheduled to be executed for the inarguably gruesome murder of his ex-wife and 2 children. He is unquestionably guilty. The dilemma is whether or not his death sentence is justified. Andre was born on March 17, 1983, in Muskogee County, Oklahoma, to Rochelle and Danny Thomas. Both are now deceased. Raised primarily in Sherman, Texas, Andre's childhood was a mixture of a harsh upbringing, but a potentially bright future. Both parents describe Andre as a good kid, but their stories in regards to each other tend to differ. His mother suggests that Andre's father was absent in Andre's life, while his father describes Andre's mother as abusive. His mother was indeed a strict woman, hardened by a past of sexual abuse, depression, and alcoholism, which was a common problem throughout Andre's family. Often their home went without electricity, water, or even heat, a hardship produced from the poverty the family endured. But despite these apparent limitations, Andre's early years showed promise. Andre has quite the head on his shoulders. As his passions tended towards construction and design, he would routinely take things apart in an effort to understand how they worked and then reassemble them with ease. Even at a young age, Andre would take his father's car apart and was able to completely rebuild it. He would spend hours sketching futuristic vehicle designs that he aimed to one day build when he grew up. Wanda Banks, a Sunday school teacher at Harmony Baptist Church, remembers him as an energetic, excited young boy who delighted in learning about the Bible. Always the first to raise his hand, and he was often able to answer her questions before she could even finish asking them.
He could have been so brilliant with the right set of circumstances,
Banks stated. What she did not know is what influence the scriptures would have over Andre in the years to come. Around the time that Andre began approaching adolescence, he would tell other students that he could hear voices in his head. He believed they were the voices of angels and demons. Before ever reaching the age of 18, Andre would attempt suicide twice, slashing open his wrists with a butcher knife. In a desperate attempt to silence the voices that plagued him, he began drinking alcohol and smoking marijuana. Whether this truly helped or not is unknown, but the voices did seem to come and go over the years. There are spans of time where Andre seemed like any other kid, happy, energetic, engaging, and making friends. He would eventually start dating Laura Boren, a fellow student with an intelligent mind and a bright future ahead of her. Laura eventually became pregnant, and in an effort to support his growing family, Andre dropped out of the 9th grade and began working multiple jobs. When their son was born, they named him Hinckley Jr. Andre gave his son the nickname Juicy, and this step into fatherhood may have well been the happiest moment in Andre's life. He was an incredibly proud father. Afterwards, Andre and Laura would marry at Harmony Baptist on March 17, 2001. As touching as all this may be to hear, their relationship was rocky, and only 4 months into their marriage, they would separate with Laura taking Andre Jr. with her. It was here where the troubles that persistently plagued Andre's mind over the years began to resurface worse than ever. The voices returned, and their profoundly destructive effect on Andre became increasingly obvious. Suicidal thoughts, hallucinations, psychotic delusions, they all became more and more frequent. The unrelenting battle between the angels and demons in Andre's mind led him towards the Bible in a bid for answers, which only increased his religious obsessions. Now living alone, Andre's deteriorating mental state made it difficult for him to keep a job, thus making it harder for him to keep his home utilities paid on time. His separation, and constantly lacking the stable necessities of water, electricity, and heat, his adult life had become a cruel reflection of his harsh childhood. With his mental health declining, it's not difficult to see how things began to spiral out of control for Andre. Due to his unstable home, Laura wisely limited Andre's visitation with his son, but it was a decision that cut both ways. On one hand, as a mother, she responsibly took the health and safety of her son into account, and rightfully kept Andre Jr. away from potential harm. On the other hand, the imposed isolation and reduced connection to those he loved only seemed to worsen Andre's mental state. Despite that, Laura was in the right to limit visitation. Laura would go on to enter into a relationship with Bryant Hughes, with whom they had a daughter, Leah Marie Hughes. Diving further into his religion, Andre became especially fixated on the Book of Revelation and a number of other apocalyptic conspiracy theories. He would place duct tape over his mouth and refuse to speak to anyone for long periods of time, believing somehow this was a means of saving the world. He would also believe that the secret of life could be found hidden on a US $1 bill. In 2002, Andre would be arrested on an assault charge, where in the police report he admits to drinking 2 40-ounce beers a day. Later in 2003, Andre would be arrested for stabbing his brother over an altercation about music. Andre had been playing music rather loudly. His brother believed that the loud music was sending evil spirits through the walls, indicating that the mental health issues in the family extended beyond Andre. On March 5th, 2004, a friend would take Andre to a local mental health clinic, where he confided to the staff that life was too much and that he wanted to die. Viewing him as a threat to himself and to others, the staff moved to obtain emergency detention warrants as to keep him under observation for treatment. However, Andre left the facility before the detention could be enacted. In the state of Texas, and in most other states, hospitals cannot detain people who check in for mental health reasons, but refuse to stay. They are required to obtain a warrant in order to gain the right to detain them. It's the responsibility of the psych department to present compelling reasons that justify the warrant. Due to this, there is a period of time where the at-risk individual can leave before the detention warrant can be executed, which was the case with Andre Lee Thomas. If the hospitals inherently had the authority to detain individuals who show sign of being a risk to themselves or others, Laura Boren may still be alive today. Sadly, that is not the case, but a nonprofit called the Texas Appleseed Project is seeking to change that, urging the state of Texas to grant the hospitals such authority in an effort to decrease the number of victims who have suffered who could have otherwise been saved. Again, on March 26th, around 7 a.m., Andre would return to the Texoma emergency room with suicidal thoughts, but this time with a self-inflicted stab wound to his chest. Dr. William J. Bowen examined Andre and came to the same conclusion: to seek an emergency detention warrant. Dr. Bowen described the following in his request. I have reason to believe and do believe that Andre Thomas is mentally ill, and that unless the person is immediately restrained, there is an imminent substantial risk of harm to the person or others. Andre has expressed suicidal ideation to several staff in the ER. But again, Andre would escape before being detained, and it would only be a matter of hours before Dr. Bowen's grave concerns would be tragically validated.
I was in the briefing room conducting the 0700 briefing. Present in the briefing room were Officer Guadea, Officer Dawsey, Officer Miller, and Officer Ferguson. At approximately 0722 hours, the briefing room phone rang and I answered it. Dispatcher Miranda Womack advised me that she had just received a call of a possible triple homicide. Womack stated that the homicide occurred at the Arrowwood Apartments, 1200 West Taylor. I turned to Officer Dawsey and Officer Miller and told them to start toward Arrowwood Apartments, Code 3. I then told the other officers to respond also. Dispatcher Womack told me that Paul Boren had gone to that location and found his daughter, Laura, and his 2 grandchildren stabbed. Boren told Dispatcher Womack he believed all 3 were dead because they were blue. I pulled into the parking area in front of Building 10. Officer Dawsey arrived shortly after I did. I approached the apartment up the stairs. As I was moving up the stairs, I noticed that the door jamb was broken and that the door was standing open. I drew my department-issued handgun and stopped at the top of the stairs to allow Officer Dawsey to catch up. I then told him that we were going to conduct a protective sweep of the residence to see if any victims or suspects were inside. When I got to the threshold of the door, I shouted in a loud, clear voice, "Sherman Police Department!" I then moved into the living room of the apartment and immediately noticed a white female lying on the ground. The white female had a large gaping chest wound and blood on her upper torso. The white female was pale and appeared dead. As I visually cleared the room, I moved past the deceased female and looked into the kitchen. I then shouted again, "Sherman Police Department," and stepped past the deceased female to move down the hall. In the 2 bedrooms that were down the hall, I did not observe any suspects. In the bedroom that was on the northeast corner of the apartment, I observed 2 small children with knife wounds to the chest. One of the children, who appeared to be approximately age 4, was lying in a toddler bed against the north wall. There was a large open wound in the child's chest and blood on the wall. A toddler was lying on the floor with a large wound in her chest. There was a large amount of blood in the crib, and it appeared that the suspect had begun the assault in the crib and then removed the child and placed her on the floor. Both children were pale and appeared deceased.
24 hours after leaving the Texoma emergency room, Andre had made his way to Laura's apartment, just as her boyfriend was leaving for work. Bryant saw Andre as he was driving and nodded, which Andre interpreted as Bryant giving Andre a blessing to kill Laura and their kids. Forcing his way into the home, he murdered Laura, his son, and her daughter, and later turned himself into the police, which his girlfriend at the time, Carmen, drove him. Police records of Andre's interview transcript reveals Andre's perspective.
Okay, Andre, I know it's kind of hard, but we need you to speak up when you talk, okay?
Okay.
And like I said, I'm a little hard of hearing, so it helps me if you kind of talk loud.
Okay. I was, before I went over there and killed, I had been listening to some videotapes with my wife's boyfriend. His name is Brian Hughes, and it was some tapes about some kind of secret organization called I don't know. The tapes were talking about, like these people that were going to like rule over other people. You know, gonna enslave other people to be like a separate class of people and made it out to be a conspiracy. He was talking about some kind of secret god clan that made a pact in the beginning that they were either all going to rise together or all fall together, and that they were supposed to come down here and kill all these people. I felt like everything was a conspiracy. Felt like everybody was listening to everything I was saying. Everything. I felt like the government was like after me. I felt like they was listening. It felt like end of the world type thing, and that they were all like listening to what I was saying and watching every move that I made. I had been reading Revelations a lot up until then, and I started thinking about time and how time really doesn't exist, you know? and how we could be living in a time when, the wool's been pulled over our eyes, like the Matrix. And I was like, well, that means we're slaves then. We're all slaves. I had the diagram that Carmen had drew on this yellow notepad with a pyramid and an evil eye. A pyramid on the back of a dollar bill. It had a door on it though, and the door was open. And inside was this man. He was laying down like he was dead, I guess. I don't know. And she said that it was me. And I was like, so you mean to tell me I'm trapped in a damn pyramid? And I was like, well, what the fuck? I didn't choose to be trapped in this pyramid. So I figured I was gonna let myself out. I thought that somehow I played this role in ending all of this for everybody. Like I was chosen or something. I don't know.
What made you think you were chosen?
I remember I had some dreams somewhat similar to it, and I related it all.
So what made you decide to kill them?
I thought that the way the guy on the tape was talking, he said that these demons and Jezebel and all these people, they could be humans, cuddly as can be. And my son kept on trying to talk to me while I'm trying to listen to this tape. I was like, hey, I'm trying to get educated. I kept on trying to listen, and the more I try to listen, the harder he tried to distract me and try to talk to me. And I was like, man, it's almost like he don't want me to get educated on the subject. Like, maybe, he was like the Antichrist or something. Maybe he's disguised his appearance or something, to look like, a little 4-year-old boy to where I couldn't differentiate who it was. My wife, she was like acting nervous. And the more I listened, the more nervous she got. So I figured she had to be Jezebel because she was scared. Their little girl was involved with it also. And the morning that I went to go kill him, I walked upstairs and I grabbed the door handle and I knocked at, and then I grabbed it and busted it open with my shoulder, and Laura came running out of the room. I already had a knife pulled and said, no. And I grabbed her and I said, you. That's all I said was you. And I stabbed her in the heart. She fell on the floor and started bleeding out. And then I jabbed the knife into her chest and reached down inside and ripped out her heart. Then I ran to the back room and I ran in there. I think I stabbed my son next with the smaller knife. And I said no, but I pushed down on his chest to steady him so he wouldn't move. Then I cut open his chest and I ripped out his heart, and then she had woken up and she looked up, and I picked her up out of the crib and threw her on the floor. I didn't throw her on the floor. I had a really strong grip on her, and I put her on the floor and I pulled out her heart, and I cut open her chest and heart. I stuffed their hearts in my pockets, and then I started to stab myself. I stabbed myself 3 times and I was bleeding. And I was like, how come I didn't fall down like she did?
Why did you bring 3 knives?
I felt like, I don't know, I would cross-contaminate blood or something. Maybe like they would come back to life or something. I don't know. Maybe they had worked out some kind of spell between all 3 of them.
Did you think what you did was wrong?
No. I thought I was doing the will of God.
What do you think now?
I don't think God would have had me kill him.
As stated, the issue of Andre's guilt has never been in question. Andre is guilty of murder. It's not until his arrest that questions start to arise, but on another matter entirely. 6 days after the murder, during Andre's detainment, he rips out his right eye without assistance or anesthesia. A statement from William Angler, who was present at the incident, described seeing Andre fall to his knees while nurses tried to tend to the wound. He saw blood streaming from Andre's face with his eyeball in his hand, repeating, "It was God's will," over and over, and adding, "I don't want to go to hell." Joe Medlin made mention of Andre quoting the Bible, specifically Matthew 5:28, which says, "And if thy right eye offend thee, pluck it out and cast it from thee. For it is profitable for thee that one of thy members should perish, and not that thy whole body should be cast into hell." Though the act of intentionally ripping one's own eye out would seem to be substantial evidence that Andre should be described as psychotic, the court system mandates evaluations be done with the suspect for verification. 3 different psychologists examined Andre after the incident with his eye, and all converged on the same diagnosis: schizophreniform disorder with a rule-out of substance-induced psychotic disorder. The term rule-out in this instance acts as a note for the purpose of any future evaluations, cautioning them to attempt to rule out the possibility that Andre's mental state was the result of substance abuse. In this case, Coracetin cough and cold, which Andre had been drinking to get intoxicated, along with alcohol and marijuana. From this diagnosis, Andre was sent to the North Texas State Hospital, Vernon Maximum Security Unit, on June 23, 2004, where he was treated for a period of 5 weeks. Andre continued to make statements regarding the Bible, his role in life, and questions about reality. At the time of his transport to this facility, to treat his schizophrenia, depression, and bipolar disorders, the patient had been prescribed the following medications: Geodon, 160 milligrams, Depakote, 500 milligrams, and ibuprofen, 600 milligrams. During his stay, Andre was restrained with hand covers to prevent further self-harm. He was administered increasing doses of the powerful antipsychotic Zyprexa, which tends to have the effects of a sedative, until he was determined to be mentally fit to stand trial for his crimes that he did not commit under the mental state that he was now going to be judged against. He was discharged from the North Texas State Hospital on August 9, 2004, and on February 15, 2005, his trial begins. Despite the understanding of Andre's unquestionable responsibility in the murders, the trial had multiple factors to consider: the health of Andre's mental state, and how to judge his crimes with that in mind. How do you accurately judge the crimes of those who are suffering from mental illness? As previously mentioned, it was acknowledged that Andre was not initially competent to stand trial, hence why he was sent to North Texas State Hospital for treatment. But this was done for the sole purpose of bringing Andre into a mental state that could stand trial. They said his psychosis was not organic, but had been exaggerated by drugs and alcohol in his system, despite evidence that Andre's mental difficulties had presented themselves a decade before the murders. Upon Andre being cleared to stand trial, 2 attorneys represented him: R.J. Haygood, who has since passed away, and Bobbie Peterson Cate. Eventually, jury selection began, which resulted in an all-white jury set to judge a black man accused of killing his white ex-wife within the state of Texas. During the jury selection, a question was posed. The defendant in this case, Andre Thomas, and his ex-wife, Laura Boren, are of different racial backgrounds. Which of the following best reflects your feelings or opinions about people of different racial backgrounds marrying and or having children? I vigorously oppose people of different racial backgrounds marrying and or having children, and am not afraid to say so. I oppose people having different racial backgrounds marrying and or having children, but I try to keep my feelings to myself. I do not oppose people of different racial backgrounds marrying or being together, but I do oppose them having children. I think people should be able to marry or be with anyone they wish. Please tell us why you feel this way. Juror number 4 marked that he vigorously opposed interracial marriages, adding to this by saying, "I don't believe God intended for this." He also went on to explain his feelings that appeals in death penalty cases should be eliminated or highly restricted, suggesting that he feels the death penalty isn't applied enough. That said, he also claimed that death penalty should not be used when the accused is insane. Juror number 5 also objected to interracial marriages and/or having children, adding, "I think it's harmful for the children involved because they do not have a specific race to belong to." Lastly, juror number 6 objected to interracial marriages, adding, "People should stay within their bloodline." Despite Thomas's counsel having preemptory strikes available, counsel neither exercised any strikes on these jurors, nor otherwise objected to them being seated. Because of this, the prosecution had the opportunity to prey on the fear of some of the jury members' disagreement with interracial relationships by asking them, "Would you feel safe knowing Andre is free to approach your daughters or granddaughters romantically?" At the trial's conclusion, Andre was found guilty and sentenced to death with an execution date of April 5th, 2023. One must wonder, if Andre were not black and his wife was not white, if he were not prosecuted in a region where such racist mentalities are found more commonly, would the depth of his mental illness been given more credence? We would not be left to ponder this had Andre's defense team taken measures to prevent these jury members from being seated in the first place. To better understand exactly what happened, I spoke with Bobbie Cate, one of Andre's attorneys that was present at the trial. The two of us communicated over a period of weeks, and Cate provided documents that would assist in the documentary. An interview was scheduled, but before the scheduled date, the emotions Bobbie was feeling became too great, and she declined to be interviewed to protect her mental health. An entirely understandable reason given the case at hand. Reading from her affidavit, you can begin to see why this case would bring about such harsh emotions in her. Her affidavit explains that Andre's case was her first death penalty case, and multiple times fully acknowledges that she was inexperienced in a case such as this. That said, she did not see this as an inherent problem, given that she was to be the second chair in counsel, with R.J. Haygood acting as the first chair, the primary representation who would be running the show in a sense. R.J. Haygood had experiences in cases like Andre's, so Bobbie looked to him for guidance. What she would experience was one of, if not the most chaotic, unorganized defense trials in her career. Haygood had assigned Bobbie to the guilt and innocence phase of the trial, while he assigned himself the task of preparing and presenting expert testimony and mitigation. The reality would be that Haygood accomplished very little, and as a result, Bobbie did her utmost to pick up the slack, despite her inexperience. Haygood would routinely make decisions without consulting his team, repeatedly taking them by surprise. RJ called two of the state's experts in an effort to prove Andre was insane, which Bobbie still to this day does not know why Haygood did this. Initially, the motion to suppress Andre's confession was Haygood's responsibility, but just a few days before it was set for a hearing, Haygood had nothing and passed it off to Bobbie, who had to scramble to prepare for it. Bobbie mentions that initially there were black jurors present in the jury selection, but the state would not select them to be on the jury, leaving only white juror members left. Bobbie mentions in her affidavit that she does not understand why that they did not challenge the state's jury shuffle, why they did not request a jury shuffle of their own, or why they failed to insist that the state's jury shuffle request be on record. Haygood did not raise an incompetency claim after the state rested their case. Bobbie is unaware as to why he would not, given its importance to Andre's defense. During the guilt-innocence phase, Haygood put only one expert on, Dr. Edward Grippen, where Haygood was responsible for examination. Bobbie, now aware of Haygood's lack of dependability in this case, repeatedly asked Haygood to allow her to examine Grippen, but Haygood refused. Grippen's testimony was not as effective as Bobbie believed it could have been, and judging by the affidavit, neither did Grippen, who was relying on Haygood to ask better questions to allow for better answers. So Bobbie made the decision to have her assistant, Leah Estep, to sit in on lunch between Grippen and Haygood, while Bobbie continued to interview witnesses for Andre's defense. Estep would note that Grippen provided Haygood with questions that Haygood needed to ask him that were relevant to the subjects mentioned in the cross. It is assumed that with these questions, Grippen could provide the needed defense for Andre that would stand a better chance of convincing a jury. When Haygood began his examination of Grippen again, he would ask none of those questions, shocking Bobbie and Grippen. Bobbie again insisted that she be allowed to question experts, but Haygood again refused. Late in the trial, Haygood asked Bobbie who they had for the punishment phase, completely blindsiding Bobbie with the question, as it was Haygood who appointed himself to cover this. A sickening feeling overcame Bobbie as she soon realized just how unprepared they were to defend Andre. She worked tirelessly through this period, but due to her inexperience in the case of this matter, felt uncertain about what it was she needed to prep in the first place. Now, hearing all of this, many may be viewing Haygood as a sort of villain in the story who didn't take Andre's case and his life seriously enough. However, Haygood was indeed a well-respected attorney who, under normal circumstances, Andre would have been lucky to have him at his side. The truth is that Haygood was suffering from chronic pancreatitis and was consistently in severe pain throughout the trial. Multiple times he had to suddenly leave the courtroom and had to take various pills in the morning and at lunch to lessen the pain he felt. Even jury members could tell that Haygood was unfocused, commenting that he looked ill, with one juror asking if Haygood was okay. Haygood would die only 5 years later after the trial, in 2010. The state of Texas didn't win this case from a superior prosecution strategy. Their victory was won from fighting against the ill and the inexperienced. I respect Bobbie's decision to decline an interview. This was not a case that she simply lost and moved on from. The case of Andre Lee Thomas was scarring, and while it's important to cover stories of this nature, it's difficult to ask someone to relive moments of pain. The same goes for Laura Boren's family, whom I contacted for interviews. They declined, and that should be respected. But Bobbie did manage to write a statement, saying,
Andre Thomas and the horrible crime he committed will forever haunt me. Hindsight being 2020, I wish I had known more, been more assertive, and been able to convince R.J. Haygood, lead counsel, to give me more responsibility. Literally having someone's life in your hands, especially someone as mentally ill as Andre, was an overwhelming responsibility. I constantly think about what I could have, would have, or should have done differently. There were no winners or losers in this ordeal, only victims. Victims of a heinous crime committed by a mentally ill person who was also a victim of our failed mental health system. And now, to add insult to injury, our justice system is going to execute Andre, a person that has been locked up in a psych ward of a maximum security prison for years. A person that ripped out not just one, but both of his eyeballs, yet he isn't mentally ill. My heart and prayers go out to everyone that have been so tragically touched by Andre's actions.
In 2005, at the age of 22, Thomas was sent to Texas death row in Livingston, where, like the rest of the condemned, he would spend 23 hours a day alone in a 6x10 cell. There, Thomas's mental illness seemed to worsen. On December 9th, 2008, Thomas jammed his fingers behind his left eyeball and pulled it from its socket. He would then eat his last remaining eye. While in prison, Andre would once again be diagnosed with schizophrenia, a clear indication that Andre's sanity suffered beyond the influence of drugs and alcohol, which was the position of the state of Texas when sentencing Andre to death. This creates a timeline where Andre was diagnosed as insane prior to his trial by multiple doctors, making him ineligible for the death penalty that the state of Texas wanted to give him. He was then doped up on the maximum amount of Zyprexa allowed, and then cleared as sane and ready to stand trial, allowing the state to sentence him to death. Afterwards, he would again be diagnosed with schizophrenia, of which there was no contest. They had their death penalty verdict. No further attention needed. Haygood and Cate would not be the only attorneys to represent Andre. Eventually, Andre would be represented by attorney Catherine Carroll of the Wilmer Hale law firm, bringing Andre's case to the United States Court of Appeals for the Fifth Circuit, the state's highest criminal court. His attorney's goals were to bring to light Andre's mental state to show that he is, in fact, ineligible for the death penalty due to the fact that in 2002, the court outlawed the execution of intellectually disabled capital defendants, a decision they reinforced in 2014. That prior decision was precisely why the state was adamant about convincing the jury and the court that Andre was in fact mentally fit to stand trial, because otherwise, a death sentence could not be legally sought. An additional goal of Andre's new representation was to show that their client no longer presented a danger to society due to his self-inflicted blindness, and as such, should be placed in an institution to receive professional help instead of remaining in prison. Lastly, Catherine Carroll intended to highlight the glaring issue of the jury that sat during Andre's trial, which led to an unfair ruling against Andre, where the cards were stacked against him. He had been in a courtroom where those who had the power to sentence him to death wanted to do so. What would ensue would be a frustrating, confusing case that seemed to only complicate things further. Audio of the discussion provides perspective into the differing mentalities of the parties involved.
As I understand you've been told, our presiding judge is listening in and speaking in from Houston. She's on a panel over there where we occasionally or quite often sit. And so this was a way to make this work out. It's an important case with important issues in it, so we'll let you get started, Ms. Carroll.
Thank you, Your Honor, and may it please the Court, my name is Catherine Carroll and I represent the applicant, Andre Thomas. Your Honors, in our application for a certificate of appealability, we've briefed 5 grounds for relief, but I'd like to focus today, at least initially, on 2 of those issues.
Let me ask you this, and the state as well. We're here on a COA. The briefs have been quite thorough. Record excerpts have been quite thorough. Is there anything further, were we to grant a COA on one or more issues that you would have to present to us?
I'd like to focus, at least initially, with the Court's permission, on 2 of the issues that we've briefed. First, that the presence of racially biased jurors on the panel violated Mr. Thomas's constitutional rights and the associated failure of counsel to question or challenge those jurors. And second, that counsel utterly failed to conduct a reasonable mitigation investigation in preparation for the punishment phase. Beginning, if I may, with the juror bias issues. As this Court recognized in the Virgil case that we cite in our briefs, it's clearly established federal law that a criminal defendant has a constitutional right to an impartial jury, and that the presence of even one biased juror constitutes structural error that taints any resulting conviction with constitutional infirmity.
What we have here is sort of a step removed, it seems. There were jurors who were opposed to interracial marriage, but it seems to me we have disagreement with a lifestyle choice. What's your best case to say this sort of belief is the kind of racial prejudice that the case law is talking about that would fit within that category?
I would point to Loving versus Virginia, Your Honor, when the Supreme Court's decision regarding the unconstitutionality of anti-miscegenation laws, which recognized that statements of the type here, which is to say not just checking a box about opposition, but the volunteered explanations that these veneer members gave for why they had those views. So, for example, Juror Copeland, who Your Honor correctly notes was never questioned at all, went on to explain that his reason for opposing the marriages was grounded in his view that the bloodlines shouldn't be mixed. Juror Armstrong, who similarly was never questioned, went on to explain that she was concerned that any children that came out of such a relationship would not have a specific race to belong to. And of course, Juror Ulmer, who was the juror who was questioned, went on to explain that interracial relationships were contrary to God's intent. Those are precisely the kinds of concerns that the Supreme Court recognized in Loving as based in fundamentally racial bias. The problem here, in part, is that there was no further questioning, no questioning at all with respect to 3 of the 4 veneer members who expressed these views. And so,
it seems to me what Virgil tells us, and you're probably about to quote it, and I'm not trying to preempt it. When Judge Higginbotham wrote a very thorough opinion, and he says that the problem here is not only what we know, but what we don't know because of the further questioning. But that runs up against, not that opinion, but that concept and application runs up against the problem also of decisions being made by counsel. And they aren't generally explained, but trial decisions, tactics, and whatever. And isn't there some information from Haygood in his affidavit or otherwise that he didn't want to pursue this in a more direct way?
he does say that in his second affidavit, which of course is diametrically contrary to the first affidavit he submitted, in which he said there was no intentional strategy, I just simply didn't ask. What we know here is that these questions were posed to the jurors, to the veneer members in the first place, precisely because the interracial dynamics of the facts of this case were so palpable that it was recognized that this was an important question that needed to be asked. So it's not a reasonable strategy to then say, well, I don't want to inject race into the discussion. Race was already injected into the discussion, and these jurors gave extremely troubling responses that precisely
I haven't looked at the questionnaire. Is that where it gets injected? Why at the time of jury selection are you saying that it was that thoroughly, and you didn't say thoroughly, that much injected?
Because it was in the questionnaire. The question starts out by explaining that there was this interracial relationship.
Meaning this particular question, not an array of questions, but this question.
There were, yes, in these
on interracial marriage.
There were 3 consecutive questions, one asking generally, do you belong to a religious institution that has views about this? Do you agree with those views? And then and then the box checking question, which was prefaced by an explanation of the factual dynamic in this case. In a capital case where the sentencing proceeding will require the jury to make a holistic moral assessment of the defendant's character and moral culpability to ultimately decide, is this a defendant who deserves to die? As the Supreme Court recognized, that is a process of deliberation where racial bias has a unique opportunity to operate undetected. And so that's why the Supreme Court has recognized, as this court observed in Virgil, that the seating of a juror like this is structural error that requires reversal and perforce establishes prejudice for purposes of Strickland ineffectiveness. The state court here, the sole reason that the state court gave for rejecting this claim was because, as the state court saw it, there was no proof that the jury's verdict was actually motivated by racial discrimination.
And the problem with this case, it seems to me, is you have an awful lot of very troubling things that you are pointing out to us, and not just that you've shown to us today. I mean, so far, you have more. But this has been looked at by 3 other courts, and the most important one is the state court. And there are responses to all of this. What would you say is the right way to characterize what we are doing under EPA to rule in your favor on this issue?
Your Honor, with respect to the 2254 D1 standard, as I've already pointed out, the state court applied a standard that was contrary to clearly established law. This court's decision in Virgil makes that clear. When the state court said that the test here is whether there's been proof of purposeful discrimination by the jury, that's what's required for the Sixth Amendment and due process claim.
That finding was made by the district state court. Are you saying somewhere in all that he's saying that's a prerequisite for relief?
That's the explanation that's the only explanation that the state court gives for denying relief on that claim, is that Mr. Thomas had failed to prove purposeful discrimination by the jury and had failed to submit evidence that the verdict was racially motivated. That's not the test, as this court made clear in Virgil. Now, with respect to mitigation, it's uncontradicted in the record that toward the end of the guilt phase, Ms. Peterson, who thought that Mr. Haygood was handling punishment all along, finds out all of a sudden that he hasn't done this. He says to her, "Who do we have for punishment?"
Well, that's how you characterize it. His affidavit, the one you, I think, don't discredit as much, says that he had been working on the punishment phase, whatever he had to show for it or not, but he does dispute the interpretation that Peterson gives to his statement.
He says, and the state court credits, that he spent many months preparing all aspects of the case. Specifically with reference to the punishment phase, he says...
Am I remembering correctly? That's what he says. I had the punishment stage. Peterson had the guilt.
In the first affidavit, he agrees that was the division of labor. Ms. Peterson agrees that was the division. Ms. Peterson's assistant, Leah Estep, agrees that was the division of labor. Everybody agrees that's what was going to happen. And then toward the end of the guilt phase, Mr. Haygood, as reported by Ms. Peterson and Ms. Estep, says, "Hey, who do we have for the punishment phase?" We then see the evidence in the Peterson affidavits, the Estep affidavits, and contemporaneous email traffic showing that they are scrambling over the weekend between the conclusion of the guilt phase on Friday and the commencement of the penalty phase on Monday, scrambling to put together a mitigation case. All of this added up to a penalty phase in which the jury saw an incomplete and misleading picture of Andre Thomas's life. What we had here was a fight about what was the cause of the psychotic break. And what the jury saw from the prosecution and from the failures of the defense counsel was a situation where Mr. Thomas, as a result of his drug abuse, suffered a psychotic break right before the murders. What they should have seen, and what would have gravely affected their evaluation of whether he deserved to die, was that as a little boy, he was suffering the effects of this organic mental illness. He needed help, he never got it. And all of that, the bias, the failures on the experts, and the utter failures to prepare a mitigation case clearly prejudiced the ultimate decision on sentencing. And with that, I would just close by, just for the sake of clarity, since I don't think I was very clear the first time, we would be more than happy for the court to go on to a decision on the merits. Obviously happy to submit further briefing if the court would find it helpful, but just wanted
Happy to return for oral argument?
Pardon me?
Happy also to return for oral argument?
If the court would find it helpful.
All right, counsel. We'll see you again.
Next, Attorney Frederica Sargent, representing the state of Texas, spoke against the motion for a certificate of appealability. But what occurred was an interesting display of Attorney Sargent having to admit fault in the state's actions in regards to the case.
May it please the court, I believe the first question was whether or not a COA should issue. At this stage, the state, while the facts, as has been noted, are certainly disturbing and complex, and some of these issues raise interesting questions, the state does not believe that the resolution of the legal issues is debatable.
No, I understand that you don't think any COA is necessary.
Okay.
But were we to grant a COA, where would that leave the state in advising the court on how to proceed?
Well, we would certainly respond to whatever they have to say on their merits briefing, but if the court was inclined to grant a COA, then the court should grant a COA. If there are any issues that the court...
Is there any way to shorten the process? I guess I should be more direct.
Direct.
If we were to grant a COA, do we have enough in front of us to turn to the merits and make that decision too without more briefing or more oral argument?
I believe you do, and of course the court has done that a number of times over the years, has held oral argument at the COA stage, determined the COA was warranted, post-oral argument, granted COA in the opinion, and then ultimately denied the relief on the merits without further briefing.
That seemed to be a little bit what the district court was doing, but that leads into the uncertainty I was asking opposing counsel about. What, even as to the juror voir dire and interracial marriage,
Sure.
The district court did say fair-minded jurists could disagree. Wouldn't that largely encompass whether we grant a COA?
To my way of thinking, it does, but again, the state's and our position right now is that no COA should issue.
Well, how do you say that it does justify COA, but still tell us we shouldn't grant it?
The district court can have its opinion about how it feels about the issues, and if it felt that a COA should issue on that particular claim, then it should have issued a COA. The state's position is that there is no entitlement to a COA.
So your position is the district court was wrong in that conclusion?
Perhaps, yes. Again, if the court felt that strongly, then they should have issued then a COA should have issued.
Well, related to that issue, on page 36 of your brief, you say trial counsel extensively questioned all four regarding whether Thomas and Laura's race would impact their ability to remain impartial. You said all four indicated it would not. You didn't give a record cite. Is it your position that when I look at the transcript, that trial counsel questioned Copeland and Armstrong as to whether or not their race would impact the ability to remain impartial?
At this point, I have to admit that was a mistake.
It's a pretty significant mistake.
It is, Your Honor, and if you...
Why didn't you correct it?
Because I did not catch it until...
Till now?
Far later.
Well, whenever you caught it.
I apologize for that, and in the future, if I catch such an error, I will correct it.
I personally, I'm not speaking for the panel, that's inexcusable. If you're saying that you did catch it, and you made a choice not to notice us on that issue, until now you're apologizing.
I don't believe it was a conscious choice not to notice the court.
All right.
I will say this, that
Okay, well, I have a few other questions about your brief. On page 41, the headings could you read do you have the brief there?
Yes.
Because Thomas was not competent, counsel were not ineffective. Is that another mistake?
Yes, Your Honor.
First not, I think.
Well, that's another pretty salient mistake. You're telling us now you meant the opposite. It seems evident.
You have that page
Okay.
in front of you that he's
Yes.
talking about? And what do you say about the heading on page 41, is it, Judge? So just respond to what would you say now about what should the heading say?
Thomas was not incompetent, is what it should read.
Okay, well then it's not just little straight typographical errors. Pages 42 to 51 are a comprehensive set of arguments, including several about Doe-Bear.
Yes.
Is there any Doe-Bear issue before us in this matter?
Your Honor, when I was reading,
I'm just asking you, is there a Doe-Bear issue presented to us in the COA?
in the appellant's brief, they raised, according to their headings, 5 issues. Those 5 issues were comprised of several multifaceted issues in the district court. When I was responding to the COA, I did the best I could with the way things were briefed, and I chose to go this route and cover all of the bases, if you will. If they say that there is not a Doe-Bear issue before this court, then there's not, and I apologize for the extra briefing. I was only responding to their briefing, which mentioned perhaps in a sentence or 2 or 3 that, in addition to all of these other mistakes that counsel made, counsel also did not make Doe-Bear challenges against each and every state's expert.
Okay.
And I felt it
Go
was
ahead.
my responsibility to respond to those claims, even though there wasn't a particular heading associated with that claim, if that makes any sense. With response to, I guess I'll start with the juror bias claim, as that's where the appellant started. First of all, the state is not contesting that these jurors demonstrated bias against interracial relationships.
What do you do with Virgil? Because it does seem to me that Judge Higginbotham took us maybe in a place we didn't have to go, but we went there in that case, that made it relevant under Strickland, that we don't know enough because of the ineffectiveness of counsel. And so we have this issue there that wasn't explored, and all we knew in Virgil is that someone was concerned because she had a relative was in law enforcement, someone else was concerned about something similar, well, maybe not similar, but a mugging, the criminal victim, her mother. But that by itself was enough for the court to decide the failure to pursue that and to find how serious it was, the intensity of that problem was enough to grant relief. So how is this different?
This is different because Virgil involved express statements in which there were 0 follow-up questions.
What do you mean by express statement?
Express statements of bias. Express statements in the courtroom, on the record, and the trial attorney said, the juror would say, I can't be fair. The attorney would say, there's nothing else I have to ask, thank you very much.
Well, what's expressed is here is, I don't like interracial marriage. I mean, that's at least a starting point. It's a certainly different starting point.
It is.
It is a clear statement of not liking what that defendant did in a racial context.
Yes.
Ms. Sargent, let me take you a different direction. Judge Higginson, you're fine.
Of course.
An issue not discussed by your colleague on the other side, and that has to do with the handling of the involuntary intoxication, the use of an expert who was not fully qualified, they say, to testify as to the effect of DXM, or whatever the acronym is, the corroscedent active ingredient and alcohol in the system. It seems to me that this does fit pretty close to the John case, another Higginbotham opinion that set some important law for us. And as I understand what John is looking at, when you have something as significant, in case there, it's the trajectory of the bullet. Could have been a ricochet, or was the person clearly trying to kill the person who died? You got to do something about it. You got to get a legitimate expert to testify. Not to have an expert on that is very much the problem that John was identifying. Why didn't the defense need a better expert who could actually testify as to this science? And then you probably don't have time, but I will accept that you also will dispute that science supports what the defense is saying. But don't they need an expert
I do
to
not
deal with that?
There was more than enough evidence to show that at least in the month preceding the murders, in the days and weeks leading up to the murders, that Mr. Thomas was pretty much high and drunk all the time, in addition to taking the DXM on at least 3 different occasions that we know about that are memorialized in the record. There was no testimony necessarily that that the substances which triggered the psychotic episode were still in his system when he murdered his wife and child. Yes, there is testimony.
Say that again, I didn't quite hear.
Mr. Hage's affidavit, there is no testimony that the substances which triggered the psychotic episode, the combination of the DXM, the marijuana, and the Old 45, the malt liquor, were still in his system when he murdered his wife and children. There is some evidence a little bit later that there were metabolites, a little bit of evidence of THC in his system, but there's just not enough there to show one way or the other whether these drugs in such a potent form were still in his system. To my way of thinking, in other words, it doesn't matter if the drugs were still in his system at the time. What matters is that he had a psychotic break as a result of the drugs that were in his system in the 24 hours before the murders. That was the issue before the jury. Whether the drugs were still in his system is, I would almost say, irrelevant, because many of the experts also testified that yes, once these drugs even leave your system, and it may take some time, but once they're out of your system, you can still be psychotic, and in fact, you may enter into a permanent psychotic state.
You don't think a fact issue could have been made, and therefore all this is irrelevant? That your evidence was conclusive, and there's no way the state, by what they have shown so far in the habeas proceedings, could have produced an expert to create a fact question?
No, that is correct. I do not believe Mr. Thomas's, the addition of these experts, the neuropsychologist and the neuropharmacologist, could have produced a fact question.
Thank you both and all who have come for this. It's certainly an important set of questions for us to resolve. We are in recess.
Despite putting forth a considerable effort, Attorney Carroll was unsuccessful in gaining an appeal for Andre's case. In April of 2021, the Fifth Circuit upheld the trial court's verdict, saying, "Thomas is clearly crazy, but he is also sane under Texas law because a jury had concluded he knew right from wrong at the time of his crime." Another dead end. But there has been one more attempt thus far in the case of Andre Lee Thomas. A request for judicial review was brought before the Supreme Court, which, if approved, that Andre's death sentence could be overturned. The Supreme Court denied the request. Of the 9 Supreme Court justices, 3 came to Andre's defense. Justice Sotomayor, Justice Kagan, and Justice Jackson wrote a dissenting opinion upholding Andre's claim that Thomas's counsel failed to properly use their preemptory strikes against multiple jurors who clearly displayed racial animus and openly stated offenses towards interracial marriages.
Thomas's conviction and death sentence clearly violate the constitutional right to the effective assistance of counsel. The contrary judgment of the Fifth Circuit should be summarily reversed. In support of his ineffective assistance of counsel argument, Thomas's lead trial counsel filed an affidavit declaring that his failure to question jurors opposed to interracial marriage was not intentional. He simply didn't do it. Thomas's trial counsel failed to object or to exercise available preemptory strikes for 3 jurors who expressed personal hostility to interracial marriage and procreation. Additionally, counsel entirely failed to inquire into the race-based views 2 of the jurors had expressed in their written questionnaire, and the potential impact those views could have on their verdict and during the penalty phase. As a result, Thomas was convicted and sentenced to death by a jury that included 3 jurors who expressed bias against him. Thomas's counsel fell far below an objective standard of reasonableness.
It's December 26th, and Andre is living out the remainder of his days at the Texas Department of Criminal Justice, Jester 4 Unit. As of today, the remainder of Andre's life sits at just 100 days. 100 days from now, a guilty man is going to be unjustly executed. Many look forward to Andre's execution, equating him to an animal, a beast that needs to be put down. Others have some sympathy, but feel the only solution is to execute him, believing that those who are mentally ill to the extent that Andre is can't be saved. Yet, the story of John Warnock Hinckley Jr. may convince you otherwise. Today, newer generations may be unfamiliar with this name, but there was a time where the mention of his name brought an equal rage and cries for execution for the crime that he committed.
This now is a tape of yesterday afternoon's shooting outside the Washington Hilton Hotel. The assailant now held to the ground, the president, who was immediately pushed into the car, being taken away. You can't see him just out of the picture, taken away to the Washington hospital.
John is the man who attempted to assassinate President Ronald Reagan, creating a day of panic and fear felt across the country. At the time of his crime, John Hinckley had fallen into deep depression, becoming obsessed with the film Taxi Driver, and somehow coming to the conclusion that actress Jodie Foster would somehow be impressed with John if he were to kill the President of the United States. He was found not guilty by reason of insanity and remained under institutional psychiatric care for over 3 decades. The road for Hinckley would not be short, as he still struggled with obsessions during his treatment, even going so far as to exchange letters with Ted Bundy and seek out the address of Charles Manson. Multiple medications were prescribed to him, and periodic, supervised leave from the hospital were allowed to test Hinckley's ability to function in society again. It wasn't until June of 2022 that Hinckley would no longer require supervision and was free to live his life once again. It's not an easy thing to come out of such profound mental illness that both John and Andre suffer from, but John is proof that it is possible. Andre deserves the same chance. It is unlawful to sentence the intellectually disabled to death. The integrity of the entire court system rests on the false determination of Andre being sane at the time of his crime. Andre Lee Thomas is guilty of murdering Laura Boren, Andre Thomas Jr., and Leah Hughes. But in 100 days, the United States legal system will be guilty of murdering Andre Lee Thomas.
I got hope for the future. I got all the love that you will ever need. I got hope for the future, and I Thank you.